Good afternoon, everybody. For those of you who don't know me, I'm Michael Scharf, Dean of the Law School, and on behalf of Case Western Reserve University School of Law and the Institute for Global Security Law and Policy and the National Security Law Society, it is my great pleasure to welcome you to the Arthur Fiske Lecture Series. And this lecture is called the USA Freedom Act, Legal Changes and the Impact on Intelligence Collection. Now, my colleague Avedon Cover, the professor who is the director of the Institute for Global Security Law and Policy and also teaches our human rights and civil rights clinic, will be introducing Catherine Lotrionte. But I just want to say I had the privilege of seeing her speak and meeting her when she was here for our recent Canada-U.S. Law Institute annual conference, and she did a great job, so we were really excited to have her back on this topic, which is really hot off the press. I think if you've been following the press, you're a little bit nervous about what the NSA has been collecting on all of us, and we're going to find out what the amendments to the statute means for the future of our, I guess, privacy. I do want to say that this is part of a collaboration between the Frederick K. Cox International Law Center and the Institute for Global Security Law and Policy. The Cox Center is celebrating its 25th anniversary this year, and together they make up our international law program, which was ranked 11th best in the country in U.S. News and World Report. Also, we had really good news. Our faculty was ranked 25th best in the country for scholarly impact, and much of the writing that we're doing are in fields related to national security law, and I'm very pleased to say that Professor Cover is leading in that field. So without further ado, I want to bring Professor Cover up to introduce our speaker and to thank all of you for being with us today.
Thanks, Michael. So first of all, I actually wanted to add also we have one other co-sponsor, the National Security Law Society. Any members of the board want to stand? Motion? Well, thank you for your efforts and support for this event. And for those of you who aren't members, you should become ones. So I don't know, people know what happened at exactly 3-4 minutes ago, 4:29 today? Back to the Future Part 2. Was what they were, the whole content of that film begins at 4:29 on today's date. So we entered the future of Marty McFly at 4:29 today. And the media has made much of what the film has predicted accurately and sometimes not so accurately. So the film has gotten kudos for predicting video conferencing, Google-like glasses, and drones. On the other hand, it's predicted flying cars, which I had looked forward to, and hoverboards, which have only been so successful. And then, sort of in that limbo state, for those of you still clinging to some hope, the Chicago Cubs win the World Series. So we may know today whether that one comes, tilts on the side of a poor prediction. But also very appropriate for today, the film depicts a Skype-like conversation between the protagonist, Marty McFly, and his coworker, which he later learns has been heard and eavesdropped on by his boss and AT&T. So the battle over privacy and security was thus predicted for the future, but it, of course, has been long waged in this country. The Fourth Amendment has enshrined a balancing of these concerns, establishing the right to be secure against unreasonable searches and seizures. But what is unreasonable? These same concerns are, of course, even more implicated in this age of big data. The quantity of data today amounts to each person on the globe having 320 times the information that was thought to have been held in the Great Library of Alexandria. On a given day, I email, I receive emails from hundreds of people. I text a friend. I text my mother. My mother tells me to call her, so I call her. Amazon recognizes my profile when I log on and tells me what books I should buy. I go to the Washington Post, and there are ads for medicines based on infections I'd been looking at on WebMD. And this makes me happy, maybe a little bit nonplussed. But on the other hand, all of my uses of the ubiquitous and necessary big data leave traces of data, of metadata. The size of the data set permits the signature aspect of what is big data today: inferences and predictions about behavior, be it shopping, voting, or criminal or terrorist activity. The government may then, sometimes with a warrant, sometimes without a warrant, gain access to internet subscriber information, cell site location information, GPS surveillance, email, smartphone contents, and telephone metadata. This information may be highly personal to me, but it may also, in another instance, prove vital to law enforcement and security efforts. It seems like it's been ages, but it's only been about 2.5 years that through Edward Snowden's disclosures, we learned that much surveillance was being done. In particular, the bulk collection of essentially all Americans' telephone metadata without the awareness of the American people and, if it is to be believed, almost all of Congress. Amazingly, however, and the subject of our talk today, Congress did pass legislation to address this program, as well as a number of other actions addressing privacy and surveillance. We're very fortunate to have with us today Catherine Lotrionte to discuss the legal changes under the USA Freedom Act and what they mean for intelligence collection. Professor Lotrionte is the director of the Institute for Law, Science, and Global Security and a visiting assistant professor at Georgetown and at the Foreign Service at Georgetown University. Much of her current work focuses on the role of international and domestic law in recent and coming developments in cyber technology and cyber threats. She has previously served as counsel to the President's Foreign Intelligence Advisory Board at the White House, as an attorney in the U.S. Department of Justice, and as an assistant general counsel at the CIA, where she provided legal advice relating to information warfare, foreign intelligence, counterintelligence activities, and international terrorism. Clearly, there are not many people we could have invited who would be better equipped to discuss the USA Freedom's impact on privacy and surveillance law and its impact on intelligence collection. Please join me in welcoming Catherine Lotrionte.
Thank you for having me here today. Hopefully everyone can hear me. I can speak as loud as I need to so you can hear me. I hope we have a lot of dialogue at the end. I think some of the most interesting conversations that I have is when we open it up to Q&A. So hopefully you've got some questions in mind, or you may have some that come up after I speak for a little while. I wanted to first, for the most part, I'm going to be focusing on the U.S. government and its actions with respect to our data. But first I wanted to, so I don't want you to think it's all about the government who has our data and is using it. We all are leaving, as we've just heard, our footprint, and it's more like our exhaust, often referred to as digital exhaust. And sometimes we're doing that willingly, meaning we're volunteering it, and sometimes we're doing it unwillingly. We don't even know. So I was going to ask first, how many of you have a Twitter account? Facebook? Gmail? Okay, so just about all of us are voluntarily giving out our data. And I can imagine if you're like the average person, you haven't really sat down and read those terms in that agreement that you signed. And at one point I was trying to make a point to my students, so I took the time to not just read through a number of different agreements. I read through Facebook's and then PayPal's. I then started counting the words because I wanted to just kind of emphasize how long and they are and why people don't read them. And from what I found is that PayPal has the longest one. It's about 30-something thousand words. So you get a sense of why people don't read it. And some of you sitting here as lawyers will understand there's a lot of legalese in those agreements. So even if someone who's not a lawyer, even some lawyers read it, you're not quite sure what it's saying that you're agreeing to. So that's on the kind of corporation side, right? We are giving our data to those companies. Now, we might think it's a great deal because, you know, I actually have a Gmail. I don't have Facebook, I don't have Twitter, but I have a Gmail account and I like it, right? It has great capacity. The university's email system, you know, I would get clogged up and I would get emails like kicked back and rejected because I was filling my quota. But Gmail, it's great. But you know, when you think about it, those companies, we say, we're getting this for free, and okay, they send us ads. That's not really all they're doing, though. I mean, we are their product. Right? They make money off of our data. And I said, you often wonder why there's no 1-800 number to call if you're having a problem. It's because you're not the customer, right? The customer who does have a 1-800 number are all the advertisers, right? And others, who they're selling the data to. But I'm not going to talk about Facebook and Yahoo and Google. I'm going to talk today about the U.S. government, particularly, and their desire to get access and how they have gotten access to data, both of foreigners but also of Americans. And so I was asked to kind of focus on the USA Freedom Act. So this was a statute that Congress passed on June 2nd of this year, so relatively new, and it effectively extended for another 4 years the provisions of the USA Patriot Act and amended the most controversial provision, which is kind of what I'll focus most on today. But it was important for a number of reasons. This was the first time in U.S. history, or since the establishment of the National Security Agency in 1952, that we saw in law some real restrictions and oversight put over NSA's authority to collect information and surveillance. Now, it wasn't an all-encompassing limitation on their authority, but it was the first real move, and there were a lot of individuals and organizations behind having this come to fruition. The reason why it happened, though, was really due to this one gentleman that you've probably read much about, and that's Edward Snowden. Now, whether you think he's a hero or a criminal and a traitor is kind of irrelevant, because where we stand now, because of his revelations about the extent of NSA's collection programs, we now are in a different state, not only of a legal framework, but also kind of a cultural awareness and a kind of a call to action to actually hold the government more accountable and more transparent with more oversight in terms of what they're actually doing in the name of security. So it is due to Snowden that we can attribute the USA Freedom Act. So what the law did not do, it's kind of good to begin with not getting our hopes up too much, depending on which side of it you're on. It did not completely end NSA's mass surveillance programs. It did not. What it did do is it did change two aspects of what NSA was doing. It required that NSA no longer hold in its own custody the phone metadata of individuals, of Americans in this case. It required NSA to no longer collect it and hold it itself, but to go to the phone companies and seek that information that they otherwise would have in its custody through the Foreign Intelligence Surveillance Act, the court that was set up through an order from that court. Now, there is a debate as to what about the data that they had already in their possession, and that's still not been resolved. But any future collection, they no longer can keep it in their custody. That doesn't mean they can't get it, but it is one more step that they have to take through the court, which for many lawyers, that was the big, if you will, pushback, that there wasn't a court system that was ensuring the oversight needed. The other aspect of what the statute did is that it actually provided for more transparency. Now, when the Foreign Intelligence Surveillance Court issues opinions, they are to seek to declassify as much and as many of those opinions. That doesn't mean that all of the opinions will be publicly available, but that we should start seeing many more of the written opinions for public review. And in the past, there had been a number of cases, they were redacted in part, but cases that my students would read. So they had released a couple of them, but of course, the ones of most concern on the dealing with the metadata program were not ever released to the public. So those are the two main changes that the law required. Most of the civil libertarians and the organizations that wanted more transparency were happy, but not completely satisfied. So it didn't solve, and this is what I want to speak more to tonight, it didn't solve the broader digital surveillance program debate. And that's where much more debate needs to continue to happen. In the future, there are a few things that I believe, not too far in the future, in fact, that will become front and center of a reform effort, and that is a different section of the Patriot Act, of the Foreign Intelligence Surveillance Act, That's Section 702, which in effect was not touched with the USA Freedom Act. That section, I think, well, it sunsets in 2017. I believe before we get to that time, and I would predict, like usual, it'll probably take maybe a couple months right before it's supposed to expire, we will see a lot of press and a lot of discussion of what needs to be changed with respect to that section, and I'll get to discussing that section in a bit. Another aspect of reform that I think will be called for is with respect to the Executive Order 12333. That has not changed. There have been slight amendments since 1981 when President Reagan signed it, but not to the core of the collection aspect that we're talking about here. I do believe that sooner than later, that also will come under much review and call for reform. And then the third category, which I think is kind of bubbling up, percolating, but will become more of a call for reform, is the classification, overall classification, and what many describe as overclassification of the information in general. So beside just the Foreign Intelligence Surveillance Court itself, but other information, other documents that NSA has. So these are three areas that are still not reformed. The statute doesn't touch them or affect the way that they've dealt with surveillance, but I think in the near future, there will also be calls to reform them. So to begin with, just a little bit about history, to kind of think back, how did we get here? So the National Security Agency was formed in 1952 when President Truman signed a classified memorandum. In fact, it's the only agency in the U.S. government that wasn't created by law, but was created by a classified document that President Truman signed. And what he did at the time is, this was at, I don't know if anyone knows the exact point of the height of the Cold War, what year, but certainly in 1952, we were pushing hard against the Soviet Union. We were in the Cold War. And what Truman saw, based on advice from other government officials, he decided he needed to consolidate into one agency both the ability to do signals intelligence, which existed within the military, and also the code-breaking function, which existed in a different part of the military. And what he did was he put them together, and that became the function of NSA, and which is still a military agency. So that in the same agency, you're going to do the code-breaking and the code-making. Right? You're going to do the signals collection, the counterintelligence, as well as you yourself are going to use your signals intelligence capabilities to spy against others. This has come up of much debate lately, probably since 2010, with the standing up of U.S. Cyber Command, which sits right next to NSA at Fort Meade, and they have the same leader, the same director. That has become a debate as to whether these two functions should still remain within the same organization, or at least under the same individual, and whether in the cyber realm we should split off defense from offense. But as it is today, it is as President Truman created it, it's in the same organization. But what changed was, after the Cold War, both the target for U.S. intelligence, the community at writ large, the target changed, and also technology developed. So after the Cold War, you no longer had one single target that was your primary intelligence requirement by every president during the Cold War, the Soviet Union. You now had multiple targets that were no longer a nation state. And non-state actors became, after the Cold War, a primary focus of the intelligence community. That meant they had to change, we as a nation and the intelligence community had to change how they did their job of national security, particularly for NSA, how you used your intelligence assets to collect against the adversaries. What also changed was communications technology. So during the Cold War, the way that NSA collected intelligence against our adversaries is that there were cables. Cables under the water, the deep sea, cables on land, in which they would physically tap into cables, right? Sometimes with the permission of the Bell Labs, the telephone companies, right? Before they actually broke up into many that we have now, there were a couple. Sometimes it was with their permission. And what you were doing is you were tapping into specific conversations, typically, for instance, with the Soviet Union, it was their embassy or individuals in the United States talking to the officials back in Moscow. And things were a little simpler then because you had one physical cable or multiple cables. They were foreigners talking to foreigners. Right? So what happened is your targets now proliferate, but those targets live and use this advanced technology that innocent bystanders are using as well. And the internet comes of age. And so now the way that the adversaries are communicating are through the same methods and means as you and I are using. And so for NSA, their mission didn't change. They still had to target and collect against those that sought to do harm against the nation and our interests. The challenge, though, was what's referred to in the in the intelligence field as incidental collection. This became a predominant problem. When you knew you were collecting on a line or a cable between Moscow and their leadership in this country, you knew you were collecting on Russians, and you're translating that, as NSA does. When you start collecting information in the internet, it's not always easy to determine who you're collecting against, right? Are they Americans? Is it a US person or not, as defined in the executive order, right? And a lot more of the incidental collection, if you're doing, if you will, this massive data dump of collection and the metadata, you can't always guarantee that they're only going to be foreigners, but that Americans may be caught up in that. So the job of minimizing that incidental collection became overwhelming for NSA. And if you've studied the Foreign Intelligence Surveillance Act, that is one of the requirements in the statute, that NSA has to minimize any incidental collection, people that are not their targets. And so these changes, because of the nature of the different targets, but also the communication technology, the job for NSA became very different. And then, of course, 9/11. And so Snowden actually, the one part, he talked about a lot of programs, and you can read about them now, and they all have kind of interesting, weird names. But a lot of what he talked about actually was already out in the public. What wasn't out, of course, was the most controversial part, that the authority of which came from Section 215, the metadata, the phone metadata of American citizens, right? That wasn't out. But the 207 section, or the 702 section, that had actually been leaked back in 2005, I believe it was. Many people, in DC, it was a massive investigation of who leaked this. This was the president authorizing after 9/11, without the permission of the FISA court, under his, unilateral constitutional authority, as the then Attorney General, by then Al Gonzalez, described it, his independent authority as Commander-in-Chief to allow NSA to collect on phone calls that were international, when one end of the phone call was overseas and was a known Al-Qaeda or terrorist member on that end of the call, and it was coming into the United States. The president authorized that on his own. That's the program that got leaked. About 2005, it hit the press. There was a lot of outrage. President's lawyers argued independent constitutional authority to do that. Judges, including FISA court judges who did not sign off on it, disagreed. Ultimately, how was that resolved? Well, it's interesting because there was a lot of frustration, a lot of press investigations about the leaks, and then things got quiet because the president announced, I think Al Gonzalez did, that they were going to put this program under the review of the FISA court. And then you didn't really hear much about it. And so maybe people thought, well, the program just stopped. Well, no. The program kept going. And the FISA court was now on board with it. Okay? So that, I think, that's the 702, dealing with the foreign, mainly targeting the foreigners. Might be less controversial for Americans, but certainly not less controversial for our foreign allies, right, and associates. And we've seen a lot of the concern voiced by them in the press. So what are there are three actually discrete legal authorities that you can point to when you think about, well, where does NSA get the legal authority to do any of the surveillance? It comes from three bodies of law, if you will. The first is not a true body of law in the sense it's not a statute, but it's treated as law, and provisions of this executive order is based on law, including the Fourth Amendment. That's Executive Order 12333. I think that's going to come under more scrutiny in the future. That executive order, it's unclassified. You can all read it. My students study it. If you're in the intelligence community, and when I was a lawyer at CIA, that was my bread and butter, because that's what I had to brief the operators overseas on, and some in the United States, on what the law was. Executive Order 1203 is also based on policy, but provisions of that order are also based on the Constitution, so you cannot violate it unless you want to, get prosecuted and, of course, lose your job. But 12333 actually, it did a number of things. What you hear about in the press mostly is that's where the ban on assassination is, right? My students get most excited about that, right? Think of Castro. So investigations start under President Ford's time. President Ford is the first president who actually drafts this executive order because he was trying to prevent Congress legislating. And Congress never did legislate. Fact, there's nothing that actually regulates the intelligence activities under the president. The president has said, okay, I'm going to give you an executive order. I'm going to regulate my own agencies so you don't have to pass a law. So there's the assassination ban, and there's the ban on doing experiments against humans, right? There's some other bad stories related to those activities, but the larger, most important part of that executive order deals with collection. Where you can collect, against whom can you collect, and what authority in the United States do you need to get? What level of authority in order to do that collection? Now, clearly overseas, that executive order actually gives quite a lot of leeway to the intelligence community to collect against foreigners overseas. I call that, when I kind of put it on a blackboard for my students and I divide the executive order into a box, foreign, domestic, U.S. person, non-U.S. person, because that executive order also defines those terms. The non-U.S. person abroad is kind of I hesitate to say this after the torture debate scandals, but it's the free space, meaning the intelligence community does not get a warrant, does not go to the FISA court, but if you have a target overseas, a foreign target, you can collect. Now, all the other boxes, you're under certain restrictions, and you have to get authority. It doesn't mean you can't do it, even against Americans in the United States, but you might have to go to the court, for instance, the FISA court, or the Attorney General if it's an American overseas. So that's actually the executive order, and nothing has changed in that order about the collection since it was first signed in '81. The second source of the law for NSA's surveillance programs to date, that's going on today, is the Section 215 of the USA Patriot Act. So that is the section that was the most controversial. That's the metadata program. So Patriot Act, you guys are all familiar with that. It was quickly signed into law after 9/11. And most people kind of think that that probably wasn't the most thoughtful and best way to do it. But, thoughtfully, they put in sunset provisions saying, okay, we're going to do this, but, the public, Congress is going to watch and make sure that how the president's using this authority doesn't go beyond what we find as acceptable. And that is where the USA Freedom Act came in with making the changes to just the Section 215. The third legal authority in which NSA operates for its surveillance programs today is Section 702 of the Foreign Intelligence Surveillance Act, Amendments Act of 2008. So I don't know if you remember, in 2008, the statute was amended. It basically retroactively made legal what the president had done right after 9/11. Because remember, there was a lot of controversy with the ISPs and phone companies. They were freaking out, basically, because now that this was all in the public, they had cooperated with the National Security Agency, and now it looked like they were going to be held in terms of liability for actually doing something illegal. So Congress retroactively said, okay, no one's going to get in trouble for doing the collection against foreigners, right, allowing that information to be given over to the NSA without the traditional warrants. So 702, basically what is now of much concern is what that does is it's the monitoring of the internet infrastructure, basically the backbone of the internet. That NSA has the capabilities to do that, mainly because they have access to most of the infrastructure, largely because US companies created that infrastructure, own it and operate it, and most of the internet traffic, even foreign to foreign, at some point passes through the United States. Now, you've also probably been reading how that disturbs a lot of countries now. They've recognized that we've had an advantage in this field, and therefore they're calling for things like data residency, right? Creating now imposing upon U.S. companies that if you're going to be in Germany and operating in Germany and have access to German citizens' data, you need to keep that data in Germany. Well, I'm not sure they recognize this at this point, but that actually is not going to solve the problem of NSA getting to that data. Because in fact, there's less legal restrictions overseas against foreigners. But I think it makes them feel better because they were quite upset about not only recognizing that we have the innovation, we own the architecture and the infrastructure, that NSA has quite a lot of capabilities. And that is one thing that Snowden revealed. You know, some people were quite shocked, some foreign leaders, as to just how much NSA could do. And reports from some of the Chinese analysts, the intelligence community said the first reaction from the Chinese was that, gee, wow, I wish we could do that. Right? I don't know if that's a good thing. Many people have talked about this in the context of cybersecurity, that this is creating an arms race, right? Now every state is seeking to have these capabilities. So I'm going to leave some time, but I want to pull back from the specific laws, and I want to talk about just 4 points, and they're broader points, and they deal with security and privacy outside of just studying the legal authorities, right? And I want to just say a few things and leave you with these thoughts before I open it up to some questions. So first, security and privacy. Most of the discussion and a lot of the writing about security and privacy has kind of characterized it as security versus privacy. Can't tell you how many times I've read even in the newspapers, but even in academic writing, certainly on news and TV and the way people talk, it's always security versus privacy. And I think this, if you think about it and characterize it in that way, it actually forces you to make a trade-off. And it's been my position for a while that that's a false trade-off for a couple of reasons. One, some security measures require people to give up privacy, yes, but not all of them. Not all. I mean, think of just locking your doors, right? Not all security measures require you to give up privacy. Secondly, think about it, privacy and security, when I think about it, are fundamentally aligned together. So here's how I think about it. If we have no privacy, right, if I had no privacy, I would actually feel quite exposed and vulnerable. I'd not feel so secure, right? Flip it around. I think about my house, my papers, my records. If my space and my records were not secure, I would think I wouldn't have privacy, right? So for me, I don't think about it as a trade-off at all. In fact, when you look at the Fourth Amendment, I think the founders got this, because the language of the Fourth Amendment itself, it says the right to be secure in persons, homes, papers, and effects. So I think they understood that privacy was fundamental to security, and they have to go together. So that's the first point. Second point, and this point comes up in the context of what you've probably read in the paper, this ongoing debate about encryption, which if you live in DC, it's very heated right now, with Comey out there pushing and the private sector and technologists pushing back. And with respect to this point, I think of security and surveillance. For me, when I think about systems and the designing of systems, so this is kind of in the cybersecurity realm, if you will, I think security and surveillance are actually conflicting design requirements. They have conflicting design requirements. I've spent the last number of years a lot of time with the technologists, with the cybersecurity experts, and I've come to appreciate how these systems are built. And so my conclusion is that if you have a system, and the experts have kind of taught me this, built for security, first and foremost. So if you get the best cybersecurity experts and they built an infrastructure, it is going to be hard to conduct surveillance on that system. It's the way they build it. It's hardware, right? It's not a choice. If you build a system for security, it's harder to surveil. In the same respect, a system that is built for easy surveillance is very difficult to secure. So one view, and not everyone agrees with this, is that these would be the security experts, that prioritizing the security, their view is if you prioritize that, the world's information flow would be much more freer from eavesdropping, of course, but also freer from theft and destruction, both from governments, from non-state actors, from criminals. The debate that this is tied to is right now the law enforcement community led by Comey arguing, and this is a flashback to the 1990s where it was then called like crypto wars, same thing. FBI was leading the charge saying that we cannot allow, then it was the export of high-level encryption out of the United States. Right, that was the 90s, and they said, if you do that, we will not be able to catch the bad guys. Right now, Comey is effectively saying the same thing. Things are a little different. What he wants to have is the ability, when he gets a court order, right? He's not saying without an order. He wants the ability to be able to go with a court order to any encrypted device and get access to it, the data inside the encrypted device, right? He wants it to be given to him, right? So you need to be able to decrypt it. You guys all heard about the new Apple phones, right? And what Cook says about it. They're not going to even keep the key. So even if they wanted to be friendly to the FBI, they could not enter a response to actually give them the data. Now, security experts have said, and many are testifying on the Hill, pushing back on the FBI as we speak, that you cannot insist on the security people developing the technology that is fundamentally flawed and less secure, because that will make everybody less secure, right? If you build it with back doors and the ability to decrypt it, you are fundamentally leaving, and we're talking about the globe here, everybody less secure. Now, people have asked me, who do you think will win out? I ultimately think it'll be like what happened in the 90s. The FBI will eventually back out, right? Just the debate will kind of go away. But right now, it's very heated, and they're not going away presently. And why I'll say it'll go away, and we won't be less secure in the sense from our enemies, because FBI actually does have other means in which to get the data. But it's not as easy, right? It's not as easy as getting it because you can easily decrypt something. So they'll have to get more money and more resources and use other investigative means. Third point, I call it security over surveillance isn't an absolute rule. Some people think when I'm talking about this, I say, oh, she's saying that, you know, taking the cybersecurity expert's position saying security over surveillance always. And I'm saying, no. I mean, I understand the reality, like there are times when we actually need to create and design systems with appropriate surveillance built in. You know, these days, we don't use the word surveillance, but there are instances, for example, tracking systems for packages. We don't call it surveillance, but that's what it is, right? We need that. The first responders who need to be able to geolocate that emergency cell phone, right, that makes a call and they need to get to that person who's in need, right? That's surveillance. That's the ability to track. So I get there are times when you're going to need to build surveillance, the ability to surveil within a design of a system. But here are some general points that most of even the security experts agree. General rules of thumb that the government should think about when thinking about these systems. And one, you design the system with the minimum amount of surveillance that's needed for it to function. And when you do that, only where the surveillance is required, you then gather the least amount of information necessary. Now, NSA traditionally doesn't like that, and I get that view. They like to gather all, analyze later, because you're always afraid you're going to miss something, and you'd rather have it all. Well, like, wouldn't we all? But this is about making choices. So the minimum amount of information, and you keep it for the shortest amount of time. Another thing, a lot of the intelligence people have said, we do not know now how valuable that information that we just collected might be in the future. So we would like to keep it indefinitely. And that's what the American people said no to. It's not an indefinite thing. There are time limits. And then the last kind of, if you will, debate about it's not an absolute, but a necessary requirement in any kind of system is you have to have the transparency and oversight and accountability mechanisms built into any of the systems with the surveillance in it. And the last thought, we kind of heard about big data. I do think when we talk about big data, there is a trade-off. And in this sense, I'm usually focused on the more negative aspect of things. I just came from a conference in Phoenix where I was on the stage and I went up right after these folks from Philips, the company, went up there and they showed this amazing innovative technology and what they're doing with it, collecting data. They're in Africa, they're increasing the healthcare. So Philips, I guess, is spinning off or going away from light bulbs. And I didn't know that, but they do toothbrushes too. But they're now focused heavily on the healthcare. And they're using big data to improve lives, save lives, right? In countries, in less developed countries that need it. And so I get up on stage and I was like, well, wow, this is going to be a big downer because you hear of all these great things that big data can do for us. But there is this trade-off because big data offers these incredible values to society. And I often focus on, well, with that comes some misuse and abuse of our personal data. So here's some of the good examples that I know of, and they're in the press every day. For instance, collecting our movement, records of our movement. I know that that's actually helped tremendously with urban planning, right? Knowing how we all move, right? And the big data, doing analytics on that. The financial records, when you have big data on financial records, that enables the police to detect fraud, right? And to prosecute individuals for fraud and money laundering, and that's all good. The wearable devices, if you have a Fitbit, right? Or the medical devices that can be used to monitor the chronically ill at home, they're wonderful things that are happening. They're saving people's lives. They're also lowering the health care cost, right? You're actually watching the people's activities at home. You can actually, for people with Alzheimer's, they can track if they're brushing their teeth. If they see that something is, now they're not doing it, they can kind of head off a problem. Maybe they're not taking their medicine before they end up in intensive care. But here's the tension. With the big data especially, and the analytics you can do on it, there's this group value, and I get it, but there's also versus the individual value, right? The group value is the benefits we talked about, increasing healthcare, lowering costs, saving lives. But what about the individual value of the data of every individual? So here I think there is a very public and transparent debate that needs to happen about how you weigh each of these benefits against the risks of surveillance, which enables them, right? It is surveillance in the use of that data. So the question is, how do you design the systems to make the use of our data collectively in the big data world to benefit society as a whole, while at the same time protecting individuals individually? And I thought back when I was thinking about the big data dilemma, I thought back to some of my IR classes and game theory, if any of you studied it. I kind of was bored, in that aspect of IR studies, but I remembered the Nash equilibrium, and I was thinking, this is kind of like the Nash equilibrium for data collection, because you're trying to seek a balance here between the individual versus the larger group and society benefits that creates this kind of optimal, if you will, overall outcome, right? That's good. But you're doing it even while you're foregoing optimizing any single facet of the group. Now, I'm not sure I know how to do that in the context of big data, but it seems to be that's got to be more of a public discussion as we get very excited about big data and what could be done with it. One has to remember that it is about surveillance. And it could be the government doing it, or it could be a private company doing it. And one must remember that, of course, when a private company has data, the US government could also get it from the private company. And the government doesn't actually have to do the collection. Okay, so that's mine. Hopefully I've left some time for questions. Hopefully you guys have some questions for me. I can get into any aspect if anything triggered an interest or even off the subject.
Any questions? Yes, sir.
Thank you. Very interesting comments and observations. If you don't mind, focus for a moment on the transparency oversight discussion you started to raise. How does democratic society deal with the natural trade-offs when the entity that is to be overseen and to offer some form of transparency itself is so capable of infiltrating the regulatory mechanisms and even the technical ones. I'm thinking on the technical side about the NSA's embedding within the RSA encryption special kind of backdoor. And I'm thinking about the NSA infiltrating Senate committees' data sets. So how does democracy feel in that?
So, on the technical side, so there've been a number of individuals that have spoken out from the private sector. So one that I thought he was quite right, I don't know if I would call him brave, because it wasn't like he had a lot at stake, was the CEO of Cisco. Remember, John Chambers, who wrote a letter to President Obama, quite upset when he found out that the US government was intercepting their, it was routers, as they were going from the United States to overseas, and they were putting backdoors into them, right? That would facilitate surveillance. Now that, I think, is what a democratic society is supposed to do, right? That when you do have revelations, you speak out and you call for change, right? And that I think is, so whatever you think of Snowden, right? I probably wouldn't like the guy, right, myself, right? And I probably think the way he went about things, and you could kind of pull it apart in many different ways, and as a lawyer, you could be totally offended by breaking the law. But the fact of the matter is we wouldn't be having a public discussion but for someone doing that, right? I'm not advocating for it, nor do I tell my students to do such a thing, but there is a place in it, like what John Chambers did, in a democracy, to hold the government accountable. Now, there are ways you can do it, right? There are different processes. I advocate for going through the legal route so you don't end up in jail, going to the IGs, right? Going to the congressional oversight boards, the committees, going to the White House's Intelligence Oversight Board, who have the ability to, one, look at and know about classified things, and then to actually take steps to hold those that have broken a rule accountable. Or even if you're not sure if they broke a rule, at least to investigate, right? So I think there are mechanisms that we have in place that have served us well in this country before, and we should keep that in mind and keep utilizing them, right? I mean, and so I think the government, the good guys in the government, which most luckily, I think I've met only good guys so far, but they have good intentions, and when they're doing things, they're always thinking they're doing this for the better of the country. I mean, aside from those few bizarre criminals who just, take advantage of the system, but I think that they forget to see that even in their attempts to do well and to secure all of us and make us safer, that they might actually be going too far at times, and they need a check, and that's why you need to have one example that is often brought up is about creating an oversight board that's actually outside the government, right? Many people don't trust anybody in the government at times, thinking that it could be all corrupted, right? Or they benefit each other and somehow, so they couldn't really be truthful about investigating each other. But you can actually create oversight boards where you bring in outsiders, right? Experts who are actually not government employees. And I know, we have at the White House now has, beyond the Intelligence Oversight Board that investigates allegations of wrongdoing and illegal activity in the intelligence community, we do have the Privacy Oversight Board. Now, there's a lot that we could criticize about that board, how slow it took for them to stand it up. Did they really have independent authority? Were they really active? Well, you first create it, and then you can do things about fixing how active they are, right? You can motivate them. But those are all means to improve the oversight. And the transparency part is a challenge, because there are going to be things that the government, and particularly intelligence community, cannot talk about publicly. But I think, and I've spoken to General Alexander about this, because when he was cyber commander, he knew he had a problem with transparency. He wanted to think about how he could fix it. And I said, it's a hard problem, but you can actually get better. It is complicated. But at CIA, when CIA was forced, because we were in a court case, and the court ordered CIA to release certain information, and at the times, unless it was going to go all the way up to the Attorney General, and there was going to be a big debate. Oftentimes, the CIA found a way to get that information to the defendant or his counsel because the judge ordered it, and there were no, from all the cases that I was involved in when this had to happen, and there's, of course, you're not releasing it all, you're redacting, you're trying to minimize damage. There were no national security crises when that happened. So, yeah, it's complex, but you need to work on transparency. But that's a little different than the oversight aspect. But you need both. You need to talk more, and Mike Hayden, the former NSA director, former CIA director, he's been very outspoken about the need for more transparency, particularly not just on surveillance, but in terms of the cybersecurity, which actually is related directly to the surveillance issues. He's been outspoken that we do need, as a nation, the government needs to be more transparent. And you need to find a way to have a public dialogue with the average citizen. And sometimes that means you got to educate them. You got to explain a lot first, because they haven't been in the government. They haven't been sitting at CIA. They don't know about the executive order. And then, okay, that takes time. And then you'll have to figure out how much of this can we release before we get to a point where that is too sensitive for the public to know. And you try to do that in as much of a broad scale as possible. In the earlier days of CIA, when there were issues that came up, when like a member of the press would find out about it, I remember a lot of the DCIs would call, directors of Central Intelligence would call the individual members of the media in to headquarters and brief them on the operation with, of course, the hopes that they would not publish it. But, that doesn't work on this scale. This is something different. It's not about bringing certain people in and explaining it to them, right, and making them satisfied. This is truly about a public discussion, like on the news, or more likely on the Hill, right, where it's everyone, and that does include, of course, the world when you do that. And that's what the intelligence community is most concerned about, not the American people, who are, most of them, have no desire to do harm against other Americans or the government, but it's the adversaries that will also be watching our moves.
I was wondering, is there any limit to the data storage capacity if we keep all this data and also the duplication of the data and its archival quality? I mean, is there a limit to the storage capacity that we have with regard to that and those types of issues, the hardware, the actual retrieval of the data, the hardware you need to obtain the data, use the data?
So if you're thinking about the government, I've been convinced, as I've seen NSA over the years, that I think there is no difficulty or challenge with being able to collect almost unlimited amount of data. I mean, so even if you look at the public open records in the world, the companies now who do the data centers, the price of storage has plummeted. It's very cheap. It used to be expensive. But NSA is also not constrained by the same kind of financial and budgetary constraints as a company may be. But I think they have almost unlimited ability to collect. And the stats show about how much information we generate now. It's being held by someone. But what I've seen is that the technological ability and innovation of NSA, it's almost unlimited. And that is why you need to have public discussion, because when you have almost unlimited ability to do something, you need to make sure that it is not being misused or mismanaged, right, by even well-intentioned people, right, going beyond what the public thinks is acceptable. But yeah, from a government perspective, certainly in the private sector, budgets, companies may be restricted, but I don't even think in that regard much, because the cost has gone down so much of storage itself. So after, yeah, so without getting into specifics, after the Y2K scare, the US government actually kind of woke up to the concern that we probably shouldn't keep all our records, like in every agency, right, in one place. we should probably have backups. So it started with the Y2K. And then certainly after 9/11, when we're thinking about physical security. So I do not have a concern that if one location or even multiple locations, the physical assets were destroyed, that the US government would have been at a great deficit or loss because of loss of data. And I think it's very easy to replicate. It's not a technological challenge and to store. So hopefully that answers your question. No, we don't. I mean, and I don't, honestly, I mean, there are many people who want it, would like it in the United States. Oh, the right to be forgotten. The Europeans, we don't have it, and I'm not so sure we'll get there in our legal system. I may be wrong, but I think for some people in the United States would like it. I'm friends with quite a few of them, right? But I don't think as a nation we're gonna be there. In the back.
Please tell me that there's something that prohibits the NSA from sharing information they collect, any information that they collect, with other government agencies.
Yes. And so, for instance, the Foreign Intelligence Surveillance Act. Now, this is, I mean, it might not make you also happy, though, either. My students, when they read the legal cases we have about this issue, they're kind of surprised. The Foreign Surveillance Act that was established, way before 9/11, allows the intelligence community, not just NSA, but intelligence community members to seek a court order from this court, not based on probable cause, but based on the target. The target has to be an approved target in the statute, so a foreign terrorist member, a foreign clandestine officer of another country, a foreign official representing another. So if you have that target, you can collect that. Now, there is a provision in the statute that says if they're in your collecting that data, you come across criminal activity, there is a requirement actually to do a crimes reporting to DOJ. That doesn't mean you can share it with anyone, but there's a number of cases. There's a case that I assigned to my students, the ISA case, and it was there was a FISA court order to surveil an individual, and he was a member of the PLO. And during phone conversations, so it was a FISA collection on phone. During phone conversations, they were collecting. He was talking to his wife, and they not only planned, but they actually murdered their daughter. And the wife was complicit, and it was a crimes referral, so it was a murder, wasn't a national security crime, and they prosecuted both the husband and the wife. And of course, their lawyers, the defense attorneys argued, well, this violates the Fourth Amendment because you don't use the FISA orders for criminal activity. But the court upheld the provision of FISA that says if you collect, as long as you have lawful authority to collect in the first place, which they did, if you collect evidence of a crime, it is legal and doesn't violate someone's Fourth Amendment to provide it to DOJ, and they can use that evidence against you in a criminal court. So there is some sharing. In fact, the judge said, my students, when we were reading, and I said, well, what's the reasoning of the court, right? We're all in law school here. The judge explicitly says, if I were to rule otherwise, what I would be effectively doing is telling federal government employees to look the other way when they saw a crime. And we can't do that. They take sworn oaths, right? So now that's not to say DOJ prosecutes them all, right? But that case, they went to jail for murder.
I'm thinking about big data, and somebody coming up with an algorithm finding crime.
Yeah, no, not that. So there is some sharing. I want to be clear. You can share, and it's an obligation to do crimes reporting in some cases, but it's not unlimited. Like most people worry about the DEA, and there are restrictions as to the intelligence community cannot just be collecting using their authority to get information that DEA otherwise could not under its authority, and then give it to the DEA, right? They can't do that. All right.
Well, we're going to have a reception. Collection right outside. You all are welcome, and you can barrage Kathleen